Hello, I'm Ted Leverette, broadcasting from partneroncall.com. For more than 30 years, I've been helping people find and buy the right business the right way. You're going to hear my conversation with Akbar Ali. He's a solicitor in London, England. He's a partner with the international law firm Berkeley Rowe. Akbar oversees complex negotiations as well as drafting and negotiating the legal contracts required to implement transactions. Our topic today is legal risks and realities amplified by the global pandemic and financial crises. This topic is particularly important for me and the people I'm advising because they're searching for and trying to evaluate businesses. The number one question I'm asked is, what should I do in the context of the coronavirus and the financial crisis? What's the effect on the small and mid-sized businesses and on the buy-sell transactions? Akbar Ali will share a few insights on several topics. They're going to pertain to the legal risks, and it's the exposures that all of us on the buy side are facing, and I guess also the sell side. So some of the things you're going to hear us talk about are non-disclosure agreements, something called material adverse changes, force majeure, maybe about insurance. We've been reading about insurance interruption, loss protection. And then if there's time, maybe we'll talk about reps and warranties and maybe if there's any insurance for that. So Akbar, before I ask you a few questions, what's today's big picture? I mean, right now for deal makers?
Hi, Ted. Thank you very much for inviting me to the conversation. I would say the big picture is, of course, to stay safe, but to keep working as well, to stay busy. Deals are still happening even right now. There are sectors which are thriving. They're doing even better during the lockdown, during the pandemic. There are sectors where business people have adapted to the new world we now live in. And there are plenty of casualties, but there are also people within those sectors of casualty where they are working on their business and taking this time to get ready for the big bounce back that's imminent.
Well, let's get right into one of the things that is an obstacle for every buyer I've represented my entire career everywhere in the world. It's the non-disclosure agreement. We don't think they're fairly written. We don't think there's enough mutuality in it. Talk to us about NDAs.
Well, confidentiality agreements, Ted, I'd say I'm completely on the same page as with you. It's a real pet peeve of mine. For some reason, the corporate world has developed in a way that non-disclosure agreements are always one-sided. They always benefit the sell side. And whereas in other areas, such as commercial contracts, day-to-day agreements, it's much more balanced. I think they ought to be balanced because it sets the tone, it sets a mutuality of understanding right from the beginning. And the buyer, whilst it can be argued that most of the information is coming from the sell side, buyers do have information to protect as well. Buyers have a strategy around how they go and find businesses. They sought advice on their approach to deal making, and that should be protected too.
You know, right now I'm representing 6 buyers. Well, actually, they're searchers, they're not buyers yet. 1 in Australia, 1 in England, and 4 in America. The ones outside of the USA are no problem. These are people buying another company. They don't care if the world knows. But in the USA, all 4 of these people are employed in executive positions, and they could be fired if it's discovered they're looking for a business. So not only do we want nobody to know they're even looking until an NDA is signed, but we also want their financial information totally protected. Isn't that something we could ask for?
Absolutely. And I think thinking about it from the counterparty's perspective, who might argue that, well, we're giving you information, you're not giving us anything that's worth protecting. Well, the terms as a result are simply not triggered. So it shouldn't prevent both sides from agreeing a balanced approach with these confidentiality terms.
Well, let's talk about something scarier. It's the second most important item to us, and we're really getting curious about it. Material adverse changes, those things that are occurring during deal making and especially after the offer and acceptance.
Material adverse changes is a very good example of a commercial element to a contract. Material adverse changes and the approach towards them entirely hinge upon the deal you've done, the drafting you've done to implement that deal. And it also is very important as to what stage you're in the deal process. If you signed a set of non-binding heads and something changes in a material way, then a discussion needs to be had and nobody is bound to proceed to completion. Whereas if you have exchanged an agreement and not yet closed or completed, as we say in the UK, then there's a grayer set of circumstances and contracts need to be scrutinized to understand precisely what the position is.
For those of you in the USA, heads means heads of terms. That's a UK term, and maybe elsewhere in the world, we refer to it as letters of intent, sometimes non-binding letters of intent. Could you give us a practical example on these adverse changes? In other words, what actually happens? The business is rolling along, and all of a sudden the coronavirus pops up, and they shut down, yet the deal was supposed to close on March 30th.
I have a farmer deal that's presently proceeding that hinges on an issue around material adverse change. There's been a slowing in financial performance. We defined material adverse change incredibly well in a great deal of detail, committed ourselves to the process, and a change has occurred. And now we've been able to rely on that drafting, that defining and finessing of the language in order to have a discussion. Had we not, we would have been in a position where we would have been duty bound in some ways, but certainly financially bound through the means of deposit payments and other commitments to proceed to completion in relation to a business which is not as attractive as it once was.
Can this be an escape clause? In other words, could a buyer say this change is beyond what we anticipated, and either I want to abort the deal, or I want to change the upfront financing, or I want to change the price, or I want to go from a fixed agreement on price and payment to an earnout? Can all or any of those be triggered?
All of the above, and in the example I've just given you, that is a renegotiation teetering on the edge of an abortive deal altogether. We are hoping for the former, of course. It's good to get deals done, certainly ones that you have committed to, but we do have a get out as a result of a well-drafted material adverse change clause.
Let's talk about God. How about an act of God, otherwise in the legal realm known as force majeure? How does that sandwich into this?
Yeah, force majeure at the moment is a term that's on the mind of every lawyer involved in deal making. We are doing drafting, we're writing articles on the subject, and it's interesting to see the transition from force majeure being viewed as a relatively passive element of a contract, what's referred to as boilerplate, to almost the center stage. So force majeure clauses have not only become more comprehensive, they are now quite express in terms of what events can be treated as a force majeure events, and coronavirus, COVID-19 clauses are being worked into force majeure as we speak.
What should buyers be looking for, searchers in particular? We've just met an owner. They're hobbling along right now. They had a wonderful business. We're not quite sure what's coming. We're wondering about MAC, and we're worried about the force majeure. What do we zero in on? And what should we be asking our legal counsel right up front?
What I would be mostly interested in doing and prioritizing is looking at the structure of a deal. If you have a deferred consideration or an earn-out that operates over the next 12 months, well, the next 12 months of trade aren't going to look like what they would have looked like at the start of this year. And it's a case of looking at the force majeure clauses and then linking them back to your commercial deal. If you can facilitate a deal by saying, very rudimentary example I'm about to give, we have a year's worth of trade. If you earn X amount, you get paid Y. Simply saying the force majeure clauses now operate to allow that 12-month period to be the following 12-month period or an overlapping 12-month period can facilitate a deal that would otherwise not going ahead.
One of the things that I'd like your opinion on is I tell buyers, particularly my clients, that they need to be conferring with legal counsel even before they begin their search, to get tipped off on here are some of the red flags to look for, because what's the point of revealing your confidentiality or hearing from the seller if the owner or a broker can't pass some early tests? Is it a good idea? I know you're a solicitor and you might think, dude, but what's the reason why?
100%. I spend, as you know, Ted, I spend an awful lot of time talking to my contacts, my clients, very, very early on in the process, often to simply soundboard. And what that does is it informs me, informs my drafting, informs my approach. There's a lot of subtle, nuanced aspects of a successful deal that all have to come into place and align in order for things to go as you want them to. And the relationship I have with my clients, with the people I work with, is such that I'm open door policy. You can access me. We can discuss my experiences. We can discuss the approach, and really just inform the process very, very early on.
So searchers, you're going to pay for it now, or you're going to pay for it later. You're going to miss out on opportunities, or you're going to waste time on dead ends. And going back to this MAC, material adverse change, you don't want to find out after putting tons of money into accountants and other people who help you do deals and have your legal counsel late in the game not be able to handle this MAC. You need to be talking to them.
Absolutely, Ted. And there are deals which, giving a very simple example again, there are deals that you simply should just not touch. And a conversation with you, a conversation with myself could give a searcher that answer very quickly, very inexpensively, if not on a free basis. And that's that. And the searcher can then move on to more valid opportunities.
What about business interruption or business loss insurance? I've been reading some articles that are pretty scary. It says owners think they have that insurance in their general liability policy. They don't. There are owners who think they have it and they do, but it's this event that we're living through now is not being covered. Talk to us about this so-called interruption and loss insurance.
Yeah, I would say with this question, we are moving slightly away from the more day-to-day transactional corporate world, but we're more into the general business world. But it is a very relevant question during this time, because the things which you've just described are happening, and they're happening more often. Businesses are presently consumed with replenishing their cash flows, interruption, lending, funding from other sources, and they are not looking at as carefully as they ought to be what they're insured for. And in many cases, the insurance doesn't cover this particular time for businesses. What might happen is down the line in quarter 3, quarter 4, that we see policy changes in terms of how those policies are implemented. But I think what businesses have to do right now is really get those insurance policies out the top drawer, scrutinize them, understand what they're covered for, understand what the risks are, and talk to lawyers. I have provided no less than 5 opinions in terms of insurance during the lockdown period. And those opinions are giving my clients real understanding as to what the interpretation of those insurance policies are. The answer is either that they aren't covered, which is an unfortunate outcome, but an outcome nevertheless, a known outcome, or they are covered and they aren't being treated very fairly, in which case they can take steps.
Okay, folks, can you take one more? Here it comes. Reps and warranties. I read another article. Actually, I got an email from a company that sells reps and warranty insurance, and I didn't look into it because somebody on LinkedIn said, well, this is only for the biggest deals, not for the small and mid-sized businesses. So talk to us about we kind of know about the reps and warranties and what our risk is, but how on the buy side can we make those reps and warranties enforceable if we cannot buy insurance?
So firstly, reps and warranties is called W&I insurance in the United Kingdom, or warranties and indemnities insurance. I've been talking to my insurance brokerage contacts a lot about this particular subject, and it is fair to say that smaller deals the premiums can be prohibitive in terms of the policy, but it's worth checking. There's a lot of advisors out there who are prepared to put in a bit of off the clock time to understand the deal, to understand what the risks might involve, and setting premiums accordingly. There are deals where you defer a lot of the consideration. There are no money down deals being done as well, albeit they're not the higher quality deals, but they do take place. Transactions of that nature, reps and warranties insurance will not be appropriate. That being said, I don't think we're far off a time where a prudent buyer currently has a team of, and as advisors such as yourself, a good lawyer, a good accountant, a good investor, a war chest of cash wherever the funds are coming from. I don't think we're too far off a time where a good insurance broker is an advisor that would be added to that team.
Interesting, interesting. Akbar, how could people get in touch with you?
I'm very available. As you know, I am very active on LinkedIn. Email, telephone, my contact information is available on our website, on LinkedIn as well. And I'm always happy to talk.
Okay, folks, how about something a little more positive, maybe even happy? This is one of my biggest tips, and it all has to do with searching, because you know what? Buying a business, it's all about search, because if you can't find it, you can't buy it. But it's about being best searchers, and it's about being first on scene for the deals that are worth doing. And you have to be first on scene with the sellers. You've got to be first on scene with the brokers, with the professionals. If you're not top of mind on those people, there are going to be a ton of buyers and searchers out there over the next few weeks and months because they lost their job or their job's in jeopardy and they're poking around. So we have to look better than them. There will be buyer competition. We might not be able to avoid all of it, but we can be better than it. So even though it's a discretionary decision by some people wanting to buy a business, they don't have to do it now. If you want to do it, now's a really good time to get better on search. Do you go with that, Akbar?
Absolutely, and I would just go straight back to the big picture of the day, what we discussed at the start. People are out there, they're working. If you are sat on your laurels at this point, your competition's out there searching for good deals.
Okay, a small commercial break. I wrote a book, How to Prepare Yourself and Find the Right Business to Buy. This is what the savviest searchers do. And then when they land a business and they're beginning to analyze it, they read, guess what? Another book called How to Buy the Right Business the Right Way. This is no nonsense kind of stuff. You'll save time, you'll save money, you will achieve better deals. I can help you deploy the tactics if you need any help, just like your legal counsel can. Go to my website, partneroncall.com. I'm Ted Leverette, the business buyer advocate with Partner on Call Network, saying thanks for listening. And Akbar, thanks for interviewing with me.
Thank you very much.